I see that people are starting to jump in. Everybody, thank you very much for jumping in. And I'm sorry I've been raising a fuss about TCPA everywhere, but I think this is such an important matter. Obviously, a lot of you guys are using HighLevel, and there's a lot of concerns that I'm seeing from what's happening with A2P10, and then as a result of TCPA. So what I have done is done a lot of research, and in doing the research, I came across Phil, and he's one of really respected TCPA defense attorney. He has helped both on the side as well as on the defense side for TCPA. Helder and I were doing some additional tech integration that has to do with compliance and TCPA, as well as A2P10 registration with using API and database and data cleansing and trying to help you make sure everything is tried to be as in compliant as possible. Now, this webinar is basically to help you to have an initial understanding what TCPA is, maybe a little bit of A2P10. And Phil is kind enough to be able to help us, and he's been gracious enough to be able to do this. And Phil, thank you very much. And please tell us about, let me introduce Helder, and then let me introduce Phil. So my name is Joe Tran. Helder, could you tell me about yourself?
Yeah, so I do custom software, and I'm very knowledgeable on building and encompassing all-in-one screens and platforms into one to optimize productivity. And I came across with building my own little necessity of needing to register my own clients and optimizing that process for A2P that I didn't have no volume of sending. So going back and forth with Joe and a couple other people about how much volume they would have, if they'd be interested on working with me on showing me some of the logs. And this idea came across about what I'm putting together is actually going to be it's going to be very helpful for agencies that have 5, 10, 50, 100 plus people that need to do their own submissions. So that's a little bit of what I.
So Helder is the tech with that understand the API, the integration with Twilio, and obviously API that we're going to need to make sure the data is cleansed and clean, and we try to stay healthy.
Yeah, and Phil, to just add on, and one of the reasons why I'm joining this webinar, why I'm here, it's because I went fully in depth to the A2P regulations, how they need to be set up.
Yep.
So we have our own diagram to help companies in understanding flows when there are single companies and what to do on each single case.
Yep, we can get into the technical stuff on that later.
So, so go ahead, Phil.
Phil, go ahead. Thank you so much.
Joe, Helder, thanks for having me today. It's a pleasure to be able to speak with both of you and everybody else here today. With this webinar, I know there's questions posed, but before we get into that, I think it'd be smart to talk about what the TCPA is and how it poses a direct danger to your business. Look, the reality is that all of you on this webinar are business professionals. Your job day in and day out is to make sales, build business, sell products, and synthesize all of those items into one package, okay? One thing that can easily disrupt your business is what we would call a class action lawsuit. So the TCPA is a federal statute that disallows numbers to be contacted when they're placed in the do not call registry. In this context, what that really means is that when you're getting leads with phone numbers to contact, whether it's by automated text, phone call, robodialer, whatever it may be, if those numbers on the do not call registry and you text them or you call them, you face potential liability if the necessary requirements are not met. Okay, so the other thing about a TCPA case that makes it dangerous for you all is that the TCPA essentially serves as the basis to file a class action. Okay, everybody's heard about class actions, right? Joe, Helder, have you heard about a class action lawsuit before?
It's too scary. Yeah. So go ahead.
So with the TCPA, what happens is that if you send one text message, or sorry, 2 or 3 text messages to one number that's on the do not call registry, and that falls into the wrong hands, What will happen, well, what may happen, I shouldn't say will, but may happen is that you may face a class action lawsuit. Class action lawsuits, even if you win, are still very expensive. Joe and I met on another webinar that I was a panelist on. And in that webinar, I was able to secure a very positive result for our client, but not after he paid tens of thousands of dollars of attorney's fees. And in addition to the time, energy, and emotion spent on dealing with a potential lawsuit versus spending that time on your business. So, in other words, the TCPA in this area is going to serve as the basis for a class action lawsuit, which may impact you personally and professionally. So, a class action, the way we describe it, is it's a procedural mechanism that enables one person to sue on behalf of a class of thousands of persons. And it basically means that one minor mistake, like a phone call or multiple text messages to the wrong number, can then lead to that class action. So, going one step further, we talk about what are the causes of a class action in the TCPA context. And the answer to that is that there are individuals out there who are serial plaintiffs who are purposely trying to find cases against people like yourself as well. And how do they do that? There's 20 different ways of how they do it. But one way they do it is they submit their phone number into a lead generator where that lead generator is not using the proper precautions. And then that lead generator gives that number to somebody like yourself. And then you try to call that person once, twice, three times, whatever it may be. And once that happens, then you're looking at serious liability.
Yeah, thank you very much for that explanation, Phil. I've read in some cases where, just like that, a lead generator actually sold the lead, an age lead, to a company, actually called that individual and passed the lead to an insurance agent. And even though they got consent and everything, that lead opted out somewhere down the line and said, I don't want to be contacted anymore. A lawsuit letter went out, and somehow that case went from a demand letter for $1,500 to a $4.5 million payout. So those kind of stuff really scare you, or scares me, especially knowing that how the TCPA rule can make the individual liable, and anybody can be named in the suit. So in this case, it wasn't just Allstate, but everybody that was associated with it was named in the suit. Yeah, prevention is so much needed, and awareness is part of being. You need to be aware before you can prevent. So I appreciate what you're doing, Phil.
Yeah, so to build off of that, everybody's thinking to themselves, a couple text messages, what do the damages look like? What are we talking about here? And the reality is the damages are quite significant. The example or the basis for of what you're going to pay per TCPA violation, meaning that if you send 20 text messages past a certain threshold, then you're liable for 20 separate penalties. And in that regard, what the penalties look like are $500 per text message or up to $1,500 if it's found to be willful. If you think about 10 text messages, that's $5,000 now that you're on the hook for, and that's just for one class member. I take it that most people on this webinar have a lead pool of tens of thousands of people. So if that number, even if it's 3 or 4%, the damage can become astronomical very quickly. Now, to give you a specific example, we were able to defend one case successfully where there was one lead was contacted and they may or may not have revoked consent to be contacted, and their number was in the do not call registry. What they were then able to do was they filed a lawsuit against our client. And in turn, what we had to do was produce a CRM software Excel spreadsheet of every number that would have been contacted and the amount of times it had been contacted. At that time, what they were going to do is they were going to run that spreadsheet with the do not call registry to find out how many numbers were actually contacted that were on the do not call registry. And then from there, determine like the actual amount of times that every number was contacted. Like I said, the damages become very big very quickly. And again, I'm a lawyer. I know you all are business people. I totally understand the fact that what we're talking about here is time, money, and investment in a product that's not going to raise your bottom line. And frankly, a lot of it is maybe a danger that you haven't previously thought of. I get that. I understand that, and I respect that. But I think one thing that we're talking about here is that we're talking about a way to spend time, money now to make the changes now so that you don't face a bet the company case down the line. Because when that happens, it's not good, even if you do win. It is unequivocally bad. So with all that said, let's talk about a couple ideas here on, before we do that, let's talk about a couple of case examples, right? Big companies are not immune from these types of lawsuits. You'd think they would, right? You'd think that they would pay their legal team or their outside counsel the right amount of money to make sure that they've been audited and that they're compliant. But the simple fact is that's not always true. And I have a cheat sheet that I passed out at my last webinar. I believe Joe has it as well. And that cheat sheet's going to be available to you after this call as well. But what that cheat sheet does is gives you two examples. One is Keller Williams. I assume everybody's familiar with Keller Williams, the real estate company.
Yep. Yeah, them and the QA core software.
Right. Keller Williams was tagged for $40 million. Again, Keller Williams is a big company, very sophisticated. They had a great legal team, but that's just what it was. Another example was eXp Realty, which is smaller than Keller Williams, but still a very big real estate company. And they were recently tagged for $26.9 million. In other words, this is an area of the law where it's very easy to make a mistake. And that one mistake, like we talked about in the class action context, can be a big problem. In terms of talking about prevention, there's a couple of things that we typically recommend to everybody. Again, this is a webinar. I'm not permitted to give legal advice. I'm not giving legal advice, but I am giving you some things to look into, whether it's to talk with an attorney after this webinar or give me a call. I'll give you my cell phone. You can reach me at any time as well. But a couple steps that we recommend is one, figure out, where do your numbers come from? Do they come from family or personal referral sources? If that's the case, you're in a much better position. Do they come from some kind of business network? Again, you're probably in a good position. If you're getting them from a lead generator, it depends. A lot of companies have relationships with lead generators. They have connections to lead generators. And what I recommend is that you talk to your lead generator and say, hey, how are we being compliant with the TCPA? Do we have the proper terms and conditions listed in the form? Alternatively, do we have the proper language at the bottom of the form saying, hey, you give express written consent to contact us? Because the best defense to a TCPA case is equivocal consent, saying, hey, I consent to be contacted. And if that's the case, you're most likely okay. Or I shouldn't say most likely okay, depending on the facts, you're in a good position. So talk to your lead generator and find out, where are we getting these leads from? How are we getting them? Then more than that, see, is the proper language in place? So the other thing that I recommend is look into arbitration. Joe Helder, are you familiar with what arbitration is?
In
Go ahead,
general,
enlighten
yes.
us.
Yeah.
Enlighten us.
So arbitration is essentially a contractual agreement to waive your right to a class action lawsuit. So essentially it makes your small problem, it prevents it from becoming a big problem. Okay. So to that end, talk to your lead generator and find out, is there an arbitration agreement somewhere in place? And then go back down and say, do you think it's enforceable or not? And again, these are all things that you should probably consult with a lawyer about. I don't recommend you doing it yourself because there's different nooks and crannies depending on different jurisdictions, which, I'm based out of Minneapolis. I believe Joe is based out of Houston. I'm currently in Florida and I'll be in Michigan next week for a different type of hearing. At this day and age, it is a national practice. It is a national issue. But with that said, every jurisdiction has its own rules, its own cases. So to that effect, I do recommend that you do talk to an attorney and say, hey, is the arbitration agreement okay or not? And if you think it's not, how do we fix it? The last recommendation I always give everybody is when they're talking to their lead generator, find out how they're storing their records. Because if you do ever get sued and your lead generator has the consent form that you submitted, or that person submitted, and it complies with the TCPA, then I think you're in a very strong position. If they don't, then it becomes a lot more tricky. Does that make sense to you, Joe and Helder?
Yep.
Yes,
It does.
absolutely. I want to go, I hope you don't mind. At one point, there's some questions that people ask within the group, and let me give you a little bit of clarity on who these people are that's in the webinar, and we currently have 36. most of these guys, like I said, they're using a software called Go HighLevel. What it is, a marketing automation platform that is similar to HubSpot, just say HubSpot. And what HighLevel offers is the ability for any marketing company to be able to white label that software to be their own. And what a lot of companies do, a lot of these guys, is they create their own brand to it. Like for me, I have my own brand to it, and they specialize in a certain niche. Some of them may be in real estate, some of them may be in mortgage, some may be med spa or legal, a variety of different niche, or maybe across the board. The concern I have for all of these guys is now they develop the messages, they develop the marketing campaign, they develop the automation process that goes along with it, with all these workflows, and they call it workflows, that is automation with it. And at the same time, they may even train the clients about how to automate and get people to convert into from lead all the way to opportunity. So they may be a hybrid where they're generating leads for the clients too. So the question I have is, now, if I know it's not legal advice and such like that, but in general, can the SaaS company or the marketing company be named in a lawsuit if their client do something wrong?
That's a great question, Joe, and I appreciate you bringing that up. So the answer is it's not clear. But I can tell you that there's at least one lawsuit that I'm familiar with where a lead generator was at least sued in part along with the defendant, or the actual caller, I should say. So there definitely is liability. It just becomes a question of what. I'm looking right now at my notes. I know of one dialing service that was found to be, or was, at least I should put it to you this way, they have found themselves in a strong TCPA predicament. And the reason is because they were robo-dialing, and they were the actual robo-dialing service. To talk to your client specifically here in terms of that they create the leads, I absolutely think that it's something that they need to be concerned about.
Okay,
Does,
so
does the
let's visit the term robo dialer, because yes, and because people think robo dialing as this sophisticated platform that you load millions of contacts and send out hundreds of thousands and tens of thousands. In this specific case, it's automation. So you have automate cadence. Hi, I see that you registered for the webinar in this case, or hi, I see you opted in for this from Facebook, and you're sending automatic messages. They don't check. Most of the people don't check the path in between, and they just send out the text, right? Whether they have to write in, they don't have the opt-in permission, right? Put opt-in permission, or if they're on the DNC list or not. Now, would that make either the marketing company or the end company would say it's a realtor? Is that trouble?
Look, I can tell you right now, I understand the position. Now, look, we're just the medium. You're right. We're not the ones making the calls. We're just the transition from the potential customer and then the actual real estate agent in your example, or the one that makes the calls. I understand that. With that said, I still think that there is exposure there. Break down that precise question, I think, would require significant legal analysis. But like I said moments ago, you definitely have a little bit of exposure. And honestly, if I'm a plaintiff's lawyer and I'm looking at ways, if I sue John Doe real estate company and I know that they have real big damages, but they don't have deep pockets, why wouldn't I bring in the medium, as I'm calling it here, or essentially the person that's providing leads to them? Or
so,
alternative, go ahead, Helder.
yeah, so from my understanding, what you're saying, so the frequency and the intensity of the situation, that's what they can use as ammunition, correct?
Yeah, again, it kind of comes down to this thing, is that to file a lawsuit, you just need a reasonable basis supported by factual evidence. There are, state by state, there are aiding and abetting statutes. I know that much in some contexts. And I do know that the medians, as I'm calling them, or the kind of the go-betweens, I think that will probably arise in some way, shape, or form. More than that, you also face the possibility that one of your clients think it's mad at you and then files their own lawsuit against you saying, hey, you didn't do what you were supposed to do. You promised me to provide safe, adequate leads. You didn't do that. Now I'm facing a penalty of $1 million and I want to come after you to pay off my $1 million. In my opinion, the lead generator or the median, whatever name we want to use for that entity or that skill set, and the client who's getting sued, they should really be on the same page. And frankly, what I would even do, and I'm just thinking out loud here, is I think it's good business practice to say, hey, we audit ourselves, we think we're good. This is why we think we're good. I think it benefits everybody. Yeah, if that's an additional cost, could that be passed on to the client? I don't know, but I do know that if I was the one trying to obtain leads, I'd probably want that.
Thank you.
Do you mind to piggyback on that topic? Do you mind answering some of the Q&As on
Absolutely.
Yeah.
so we can
Yeah.
start with
Well, I
Joe?
want one more
Yeah.
quick question before we jump on the Q&A. So one of the preferred campaign that people suggest in doing, even the white label company, in fact, they have the automation pre-built, is doing something called database reactivation. Okay. And what that is you tell your customer, hey, you have a list of customers, you have a list of leads, load it into our system and send out text. Is that dangerous?
I think it is. I do think it is. I think it's very dangerous. I think that if you're sending out mass texts and your numbers are not being properly audited or vetted with the DNC list or with some kind of consent form, then I think you're asking for trouble. In my opinion, again, I'm one attorney, I have my insights, somebody else may think differently, but I do think that if you're sending out mass text messages without properly scrubbing with the DNC list, which we can talk about here in a second, or making sure you have consent from your people, then I think you should really take a lot of time and reevaluate what you're doing. I'm not saying it's wrong, but I'm not saying it's right either.
Now,
So-
would you do it, Phil? Would you do it? You don't know if your client has consent.
What I would do, first things first is I'd find out where my numbers are coming from. I know I keep harping upon that, but it sounds maybe like I'm just a broken record, but in my opinion, if my numbers, I'll give you an example, right? If I'm a real estate company and 20% of my numbers come from open houses where somebody puts their phone number down and has a phone call with the real estate agent or is a friend or family member of an agent, I'm not that worried about those people. And there's a number of reasons for that I could get into, but those numbers I'm less worried about because there's a certain established business relationship there or a personal relationship that will put you outside of the TCPA context. If I'm getting my numbers from lead generators, I'm looking at, is the proper language there? Number one. And then number two, are what other protocols are in place with my lead generator to protect me? Like I said earlier, arbitration's a possibility. Are they keeping records? If those two things are in play and we have the right consent language, I probably sleep pretty well at night. Now, remember, everything's fact specific. There's no one cure-all position of this, but that's something that I would feel a lot better about if that was available. The other thing, go ahead.
Go ahead, Phil. Go ahead, finish the statement.
No, so those are the main points that I would do. And I think it's generally pretty easy to say this as a person not in the industry, is that it's relatively doable to figure out what percentage of your numbers are coming from where, and then start there and work your way up.
Great. As a operator, business procedure, what would be helpful is for your clients to be able to tag where the lead is coming from. I think that's very important. So they can say, hey, this lead came from an open house. And maybe even the open house will have a consent on there, right there, saying, hey, I consent to getting texts or messages, and you have documentations on that, then that would be safe. Now, the other thing that I found out, and I don't know if it's true, is Florida TCPA, the mini TCPA, is scary, a lot more scary than the regular TCPA. I've also read that prior established content or prior established relationship, even they're your clients, it cannot be loaded into ATDS. right? Now, that to me, just I talked to several friends like in the leads, and they go, "Yeah, we stopped doing business in Florida altogether. It's too scary." You're in Florida. Are you there for vacation? Or are you there because of a case related in Florida?
Am I right now while I'm in Florida?
Yeah, yeah.
It is not TCPA related.
Okay,
No, but I'm here for unrelated reasons. But you're right that there are state-specific TCPAs, TCPA laws. Oklahoma is one. I believe Washington State and Michigan are other states that either have or will likely form some kind of TCPA legislation in the coming years. And I'll be honest with you, I don't think the TCPA is going away. We are a divided country in a lot of ways. But if you look at it politically, this is the TCPA is the one legislation that brings everybody together because you have a lot of different politicians on all sides of the aisles working hard to pass these laws. And I don't think they're going to go away. I think they're going to get worse.
Yeah, and to add on to it, also New York and Pennsylvania as well, to the that states that have mini TCPA with their own protection of consumers and compliance with their own business hours and so on, correct? Do you want to enlighten people what the mini TCPs are that each state is on federal?
Without delving into each state specifically, because I don't have that information offhand, I can provide it if somebody would be interested in that. But with that said, it's not every state has different rules, and you got to make sure that you follow those rules as well. Because when we talk about the TCPA, is that it's a federal statute, meaning it applies across the country. But it's also possible that you could be compliant with the federal law and be non-compliant with the state law and face similar or worse exposure.
Yeah, correct. Can we answer some of the questions to piggyback on before the topics on compliance and how is the agency liable? At what extent is the agency liable? So Jason, Don, and then Joshua, they have.
Yeah, what we want to do is go from top down and try to answer each with a question. Yeah, Edwin had a question. I don't think consent could be transferred. Could consent be transferred?
That's a good question. And there is actually case law on this topic. There have been cases where I think one thing, and this is not official legal advice. I'll reiterate that. From my experience, is that I believe there are cases out there where you have one person submit consent to be contacted on a phone number, but not actually owning that phone number. So for instance, I could put Joe's number into the consent to join form, and then Joe gets a call, and then there's a violation. So do I think consent can be transferred? It's tough to say. Generally speaking, I don't think it can. The better way to look at it is, a different way to look at it is if you have consent at one time, can that consent ever be revoked? And the answer is it can. So said differently, I could say, you can call me anytime you want to. I have no problem with that. And then 2 years later, I say, don't ever call me again. And I text the number back, or I call front desk person at your company, or I put my number on the do not call list. Did I revoke my consent properly to be contacted? That's a good question. And the answer is you very well may have. I very well may have. So looking at the transfer of consent is one thing, but I think what that question touches upon that's a little bit more maybe relevant on a day-to-day basis is can it be revoked? The answer is yes.
Okay. So do you think best practice for this, maybe when opt-ins have a 2FA system to verify, to make sure that the person on the spot filling out the consent is not a bot or someone overseas trying to spam forms? Is that a best practice? Do you think that will be helpful?
Yeah, in terms of the fake consent form, I don't know. That's a tough question because it's just, you want two-step verification. It depends on what your system looks like. If your system's the type of system where, the only one method of consent is only way it's going to be realistic, it's hard for me to say do double verification. I guess to that end, what I'm trying to say is I don't know if there's a good answer right now. I'm being upfront and honest. Is there a better answer out there? There may be, but again, we have to kind of look at that on a specific basis.
Awesome. Thank you very much, Phil. Okay, now Joshua Novak.
No.
I think he's.
Yeah. So let's go on Bradley, and then let's continue down the chain on the questions.
Okay, Bradley. How do they know when the consent was added to the form?
That's a good question too. So in terms of the consent form, there is typically some kind of data out there that tells you, I think it's like a web page. There's a specific term for it, but it's like a weblog, I think is the term, when that person actually put in their consent to join or their consent to be contacted. So you typically have that piece of data available. But like I talked about earlier today, make sure your lead generator is keeping records of that. It's if you want, or sorry, if you are the lead generator, make sure you're keeping records of that for your clients. Because the first thing that's going to happen is if one of your clients gets sued or you get sued, is you're going to say, did this person have consent or did they not have consent to be contacted? And the best piece of evidence for that, in my opinion, it is that weblog that says, hey, they consent to be contacted. To give you a specific example, if I got a phone call or some kind of text message or whatever on Tuesday, but I consent to be contacted on Monday, there's no issue. And oftentimes, what I will also tell you is that oftentimes plaintiffs forget who they gave consent to be contacted to. I'll give you an example from my life. I was looking to buy a house and I put my number into the consent form. And 6 months later, I got a text from Coldwell Banker saying, hey, are you interested in this house? And I said, what, why are you guys having it? Like, oh, that's right. I submitted my number back 6 months ago. Just on a general note, people forget how often they give their phone number out online.
Thank you for that. Yep. Continue.
Let me add to that, Phil. I understand that the FCC is updating the TCPA rule where consent it can't be passed to multiple lead companies. I think they're working on that to everybody. I don't know if you can go to a website, fill out a form, and they sell that lead to multiple organizations. I think that has the potential of being shut down by the FCC. So, Philip, and if you have any comments or anything on that.
No, I'm not personally familiar with that. It does sound like a practice that's most likely going to be shut down by the FTC in some way, shape, or form. But in terms of, like we've talked about, bringing it back to my favorite saying on this webinar, where are your numbers coming from? Because
consent form, consent form, and making sure even if you're reselling that you have that person's consent. So if any of these people, any of these bad actors get in trouble, you can at least cover your behind that we had the consent and now the person is just, you're on the receiving end of our spectrum.
And here's the thing too, is that just because if a caller has consent, sorry, I'll give you an example. If a caller has consented to be contacted by me, it doesn't mean that they've necessarily consented to be contacted by Joe or Heller. That consent may not transfer to another caller.
Okay, that kind of answer, I'm trying to go look at the questions that came up. And I think Samir asked that question, can that consent be transferred to a foreign company that may be doing calling for the agent or for the company? For instance, there's a lot of us in here, and there's a lot of promotion within this group to use VAs or third-party calling company. Use us, we can follow up on the leads for you. We can call them 10 times or 20 times until they answer. Ultimately, if another company does the calling on behalf of you or your client, could you be liable if somebody else is calling for you, the organization?
Again, that's a fact-specific question. But I think in my mind, what I would try to do is if I'm a plaintiff's lawyer is I'd try to group you in as well. Because look, one thing we haven't talked about is what does litigation look like? But if you get served with a copy of and I'm not trying to dodge your question, I'm just
Sure.
trying to tell you is that even if you have a foolproof plan, which I'm not saying this plan is, it's just kind of fact specific, but even if you have a foolproof plan and you still get sued, you're still going to be out of pocket quite a bit of money. You know what I mean? Because whether you hire my firm or another firm, federal class action litigation is not cheap. But to make this defense, even if you're right, is going to cost you out of pocket 20, 30, 40, 50, $100,000, and you still may lose. And if that happens, you've lost a lot of time and a lot of money. Typically what I advise my clients in TCPA context, or really any context is can you think of a workaround? Sure. Is that workaround going to prevent you from getting sued? It's not. And if it doesn't, then you're in a position where you're still outlaying a lot of money rather than maybe just tightening up your programs in the beginning.
Yep.
Okay,
Yeah, I was gonna say, I have Tom. He wants to bring some input on this large specifically exposure. Tom, you can go ahead and unmute yourself and.
Yeah, so specifically around, can you guys hear me okay? Did my mic turn
Yep.
on? Okay.
Yeah.
Yep.
Yes,
Specifically around several of the topics you guys are touching on. I know that Philip raised a couple of names there. There is an active case going on right now. There was 2 of them filed against Allstate. Allstate settled one of them right off the bat. They just paid $120 million, no questions asked. Boom, boom, done. There's one that's pending. That is a case that the lawyers just won a couple of months ago, the right to get Allstate's internal do not call list for their company. Okay, so now because they have that list, the lawyers are combing through that list, matching it up to every single call that was made, adding that into the calculator of what this is going to be. It is going to be hundreds of millions of dollars that they know they'll have to settle for. And the way that happened was, to Joe's question he just asked, Allstate hired a marketing company. We're the marketing company. They wanted us to do they wanted them to do marketing for Allstate. That company went out and hired overseas dialers, got on the phone dialing for the marketing company. The marketing company and Allstate are both in the crosshairs. Why? Allstate did not quickly enough pass their internal do not call list down the chain to the overseas dialers. The overseas dialers were dialing people that were not on the US do not call list, may not be on some state mini list, but they were in Allstate's database of do not call. So the lawyers now have a list of hundreds of thousands of names from the Allstate company list that they're sorting through to see how many times they dial. So can we be in the line of fire? Yes. And if you go hire overseas dialers, does it get you out of the way? No. It puts you more in the line of fire, because you've got to be able to get that company specific do not list from your client to get it to the dialers to scrub against that as well. So there's a lot to it. It's why I wanted to be on this call to see what insights you guys might have. But that specific case is going on, and some people are estimating that settlement may be 400 or 500 million.
and a lot of companies, they think just because they're offsetting overseas, they're going to remove compliance. They're gonna find a way that who hired them, and then they're going to take it back to the US so they can start pinpointing, and they're going to go after the US company. Just because you have an overseas dialer, that doesn't get you out of the way of the line of fire.
Yeah, and Philip, my one question for Philip, that's my input. My question for Philip would be around another feature that we have in those applications like HighLevel, is called a missed call text back. And there's a lot of questions in the group around that. People call you, or they call your client through your automation platform, and they get an automated text back saying, sorry, we missed your call. How can we help you? And they may or may not have put a link on that, which I wouldn't. But so in that scenario, is there any way a person could potentially be sued just for sending a reply text to a call from a person's number?
So basically, let me explain this or understand this better. So your client gets a phone call, and using your software, they automatically get a text back saying, hey, we missed your call, but please reach out to us at XYZ.
Correct.
Look, again, we just talked about this, Tom. My general position is that anything's possible in this realm. I think if they're calling you, I think that puts you in a good position, because it seems like there is a business relationship there. Yeah, anybody can call you. That's not an issue. If they call you and you call them back, that's usually okay. So I guess my point to you is that's a good question. And I think that's probably okay. But again, I can't give legal advice on over a webinar. To me, on the surface, it sounds like a reasonable practice that's not going to run you afoul of the TCPA. And my conclusion for that is that the original caller is calling your client, not the other way around.
Philip, we're going back to the frequency. We're going back to the frequency, to the intent, and to these points of behaviors, correct?
What do you mean by that, Helder?
So how long did the callers trying to reach out the end user? What is the intent? Did they answer the call? Were they persistent on it? Were the intention of business, the relationship that was established?
So I think with Tom's example, I think it mainly goes down to if there's a business relationship and they're calling the client directly first, I think that's a pretty good spot. If you're calling and they're calling you back, that changes the dynamic a little bit. But at the same time, I think you're probably in a little bit better position than a mass text. Like I said, there's no one size fits all here, but if it's an automated text to a phone call that you're receiving from the other side, To me, on the surface, it looks like it could work. I'm not saying it would work, but it definitely could.
Okay, so it's like the same kind of flavor where you get a lead from Google Forms or something like that, and you respond back. I would assume it depends on the opt-in language. If you get on the form, whether it's either on your website or where on Facebook or wherever you get the lead, as far as the consent.
Yeah, yeah. Look, there's the statutory consent that you need to comply with, but there's also, in my opinion, you can go above and beyond that and say, hey, look, you're going to permit me to call you XYZ times. I think that's there as well. Again, we're, and this is, I think, my fifth time saying this, but where do your numbers come from? And if they're coming from the right source with the right consent language, that's great. If they're not, then maybe it's time to consult with an attorney.
Okay. So I just saw another funny question by Brad Dickey. Okay. And Brad said, funny, and this is my interpretation. I work with doctors too, and he asked, what if a dentist sending out requests for a review, if they're sending text messages? For me, I have clients in Florida, and unless I know, even though it's your client or your patient, I don't know if you got consent for it. That's one rule. HIPAA is another rule. So for me, I would be scared to send out and use my HighLevel. So Phil asked, would that be a problem if you starting sending out reviews to people?
So again, look, every scenario is fact specific. Can't give a yes or no answer on this. But generally speaking, if you have an established business relationship with most of your clients, I think you're in a good position. In terms of HIPAA, if you're talking about reviews, I guess the question becomes, what kind of reviews are we talking about here? For satisfaction, 1 to 5 stars, you're probably not going to run afoul of any kind of HIPAA issues. And more than that, as long as the communication is essentially controlled to the medical provider, the dentist in this example, and the patient, I think it's okay on the surface again. And the reason why I say it is because essentially you're communicating between the dentist and his or her staff and the patient.
Okay, awesome. Thank you, Phil. Let me jump to having station as, let's see. Okay, so if a client is doing non-compliant sending, I think we're getting back to this. What's the best way to remove responsibility from us as just the white labeler? So,
you know what? That's a good question. I think in terms of that regard, I think the best way to look at it is to look at it in terms of your relationship with the client. Do you disavow yourself of any kind of liability for their non-compliance? Look at the contract. Do they have a duty to indemnify you if they get sued or you get hit with penalties as a result of their actions? I think the way to look at that is a very specific legal question, is to say, what contract or what agreement do you have with the client and with yourself? Because if the agreement says they have to indemnify me and pay for all of my defense, and I require them to take out some kind of insurance policy to pay for that, it is what it is. Alternatively, if there's nothing in there, then maybe you look at that and say, hey, either you be compliant or you got to pay for some kind of defense policy if and when you ever run afoul of this. And it causes me problems, I should add to that as well.
Yeah. Thank you, Phil. We have a very broad question from Don, and my opinion is there's no 100%, but I'm going to ask it anyway. He said, what exactly can we do with the GHL platform to make sure we are being TCPA compliant? How do we make sure that we have and come through consent within GHL? So in other words, what is consent? What do you need to define as consent?
The way that I look at it is you have to make sure the right statutory language in the consent form. But you really, I think for that answer, what you need to do if you want to be as comfortable as you can be is to do what I would call a TCPA audit of sorts, and essentially bring somebody in to say, hey, we do XYZ tasks. Are we TCPA compliant or not? And then hopefully what that lawyer will do, whether it's me or somebody else, is then going to essentially give you some kind of strong recommendation. Do you comply? We think you do, and here's why we think you comply. Do you not comply? Here's why we think you're non-compliant. There, you want, like I said, and I've said this before too on this call, is that there is no one size fits all. This is an area of law that's evolving. It's changing. There's going to be state law specific questions as well. And with all of those things in play, what we're talking about here is a moving target in the sense that if you fix it today, in 2 years, it may not be fixed. To that end, what I think, if you want to be 100% sure, I don't know if 100% is possible, but if you want to be 90+% sure, I think the only way to do that is to consult the TCPA professional and kind of work down that audit system saying, hey, our leads, we know where our numbers are coming from. Our leads are good because of the consent language. We are scrubbing our leads every so often, and we know that we're okay. So that's probably what I would recommend. I know it's not a great answer. I know that Don came here probably for a clearer answer, and I can't give that to him. And I apologize for that, Don, but that's the reality of the world that we live in here in the TCPA.
Thank you so much, Phil. Okay, now Jason Holliam had, Jason, if I pronounce your name wrong, I'm sorry. If my number come from opt-in form with implicit and explicit content, am I still at a higher risk target?
So again, it's hard for me to answer that question without knowing what kind of work you're doing here. If you're sending mass texts and you're not scrubbing your numbers and there's implicit or explicit consent, I'd say you are. If you're getting your numbers from a lead generator who's got the right language in the consent form, it's clear and obvious to the individual who submits the consent form, then I think you're probably a lower risk target. But again, the best way to go through that process is, I think, to engage with a TCPA professional and make sure that consent is being obtained properly and explicitly, something to that effect.
Okay. Now, as far as consent, does that expire?
Good question. As far as I know, it does not expire, but it can be revoked. And the question is, how is it revoked? Obviously, there's the example of, look, I consented and I called you or I texted you, say, don't contact me anymore. Another way where it is much more blurry is if I put my number on the do not call list, but I don't tell you about it, is that a revocation of consent? And right now, the answer is, I don't know. I don't think the court knows. I don't think anybody knows. But that may be an issue that arises down the line. So the best way to guard against that, the DNC, DNC list is the do not call registry. It's online. Basically, people can put their phone numbers in there anytime. And on that do not call registry, once that number's there, it says do not call. But in this context, what I would suggest is periodic scrubbing with the DNC list to say, hey, Joe gave us his number a year ago. We're still contacting him. If we're contacting him, then hey, let's make sure he's on the DNC list, because if his number is in the DNC list and we keep contacting him, then I think you are a medium target to a high risk target, because it's not clear. And like I said a little bit earlier, is that even if you win your class action lawsuit, you've still lost a lot of money.
I agree with that, Phil. Just being involved in a lawsuit, that's money expense out of your pocket. Like the case that I referenced for a marketing company, it was just one phone call, and that resulted in a potential case, and they asked for a class. Phil, you touched base on something where the plaintiff, meaning the people that are suing you, the plaintiff can ask for your records. Can they ask for your customer list? They can ask for your DNC list or your do not call. Is that allowed? Basically, we're giving evidence against ourselves.
Right. So what you're referring to is a discovery process in federal court. So in discovery in federal court is limited to the proportional needs of the case. But damn near every TCPA case that gets filed is going to be filed as a class action, because it means more money for the plaintiff's lawyers. And what they're going to allege is this is a massive class action case. And because of that, we need all the information on behalf of all class members. And who are all class members? All class members are the people who were contacted by your agency or by your medium, whatever it is. And those people are potential class members. So yeah, I think that information is very discoverable. I think that 9 times out of 10, the judge is going to say, give them the information. I think that's what's going to happen. I think that
So,
would be a very hard fight to win.
so do you need to now, do you as a company or SaaS company or their customer need to maintain that record of when they're calling, how they're calling, what is texting? And like you mentioned, you got to give something. What is it that you got to give to them?
So to that end, a lot of people that I've represented have CRM software, and that tracks all that.
Okay.
So that information is most likely being stored, even if you're not doing it purposefully or not. If we're talking about what the medium, that I've been using that word, but if we're talking about what that person should be doing, I don't. Should they be storing records of every phone call made? I don't know if they're required to do that. I think the better way of looking at it is saying, okay, no, phone numbers have been, or sorry, calls have been placed, but again, we're just the people that provide the phone number. It's not really our job to store that information. What I would store though for my clients though is the date of the submission form or the consent form, things of that nature. That's the information that I'm referring to when we're talking about storing and recording information.
Thank you very much. I read published today in the news where there was a default judgment. Some guy sued the company and he said, I got 300 texts. And he filed that or text or X amount of calls to a company. Can the judge make a summary judgment based on just what the summary is saying, whether it's fact or not fact?
Do I think that yeah, look, summary judgment is a legal procedure where essentially the facts are what the facts are, and one party asks the judge to say, based on these facts, which are not contested, there's only one conclusion to draw here. And to that end, what I think is that if those facts suggest, if those were the undisputed facts, then it is what it is. It's absolutely possible. If there was a default judgment, which is a little bit different than summary judgment, again, the same may have applied as well.
Okay. Now, as far as the fines for TCPA, are making phone calls and SMS the same, and are there different penalties? Because I've heard that if I get a text at 5 in the morning when somebody that didn't register, is that one fine, two fine, or can it be compounded?
Oh, yeah, so the way that I look at it is it's $500 per text message or phone call. So if you send 3 text messages, it's $1,500 at a minimum. There's also an argument for it to be $1,500 per text message if the violation is found to be willful. Well, that's a different ball game. We don't need to get into that today. But basically, if you're being willfully non-compliant with the TCPA, then sometimes the court may say, hey, it's not 500, it's 1,500 because you've done this before, or you purposely disobey the TCPA. So whether it's a phone call or a text message, it doesn't matter.
Based on contact records, and then some agencies or some softwares have HIPAA compliance. And let's just say that the master account has an account that has all these records on HIPAA compliance. Let's just say the agency shuts down and now all of these servers and this information is destroyed. If now the person that the business now gets sued, gets into class action, how can they get protected by this? Since the records were, what happens on this scenario?
Let me rephrase, Helder. Is basically how long should a company maintain records even though they're not using you anymore? Are we is the SaaS owner responsible for keeping that record of all the calls and the transactions, or what does that mean? And for how long? For how long too?
So the statute of limitations is 4 years. So if you violated the TCPA 5 years ago, you got nothing to worry about. But 4 years is typically the length of time where there's a possible violation. It's 4 years from today. So that's what you're looking at here, in my opinion, is if you're worried about something, or if you're a client that your team service, I want you guys to store the information for at least 4 years. Maybe longer, depending on other factors as well. But I would say 4 years is at least the baseline. It's the minimum for me to feel comfortable moving along through this process.
Okay. So with that, as far, and you mentioned about the business relationship and the contract with a client. I know I'm moving forward with any new client that I'm going to discuss TCPAs and what are the rules and what records needs to be kept. And that has to be, we have to figure out if they leave me and we're doing marketing with them, what are the costs and how is that going to be handled? So I don't know how that's going to work. I just know that I'm going to be considering that. I will be obviously getting legal counsel on that so that we can stay in compliance. I think we're at the 1 hour mark. So the hour went by really fast here. What I wanted today was really help Phil come aboard and give us a little bit of expertise on what's going on. Phil graciously said, like I said, I discovered Phil in another webinar and he had this checklist. And I'm not going to go, guys, I have this checklist. Here you go. But I asked Phil in the very beginning in the contact, hey, Phil, do you mind if I give everybody a checklist? So whoever registered, I'm going to be emailing you a checklist. Really, there's still a lot of questions and both technical and legal questions that we don't know. We don't have the answer for. We don't know how to proceed with this yet, but in communication with Phil to maybe do additional, maybe a master class or a mini class, Phil has to really take it to his firm as far as compliance, what can I do, or ethics to see what can be possible. So we don't have answer as far as Phil and what we can do, maybe as a group or an individual. Individually, you're going to have Phil's contact from that sheet. You're going to get that, okay? As a group, I don't know what we're going to do yet. But as far as the technical side, for the ATP 10 registration, I don't know if we officially announced it, but Helder and I were creating a software while Helder is doing it, I'm helping promote it. I don't know anything about programming, to create the registration with Twilio, so at least you have that part taken care of, so you don't have issues on that. I have some other things that I'm working that's more on the coaching side that will help you remove on the cell phone so that you or your client doesn't show up as spam, and that your SMS will be in the main inbox and not be subject to saying, hey, this is junk, do you want to report it to the carrier and the phone provider, which could be Apple. So I'm working on that. Now, we're going to send a webinar replay to this on the page or somewhere. We're going to have a question to see if you're interested in whatever. And if you are interested in whatever, when we figure out whatever that is, then we're going to respond. We're going to get back to you. Phil, does that sound okay, or is that right?
Yeah, like I said, in terms of a group or a one-on-one consult, we have to figure out, I have to comply with my ethics counsel. There's a number of different rules about offering educational services. What I will say, though, if you need emergency help in the meantime, my cell phone is listed on that cheat sheet. It's 513-658-8802. Please feel free to give me a call anytime. I'm happy to help.
Okay.
Cool.
How did you have anything else to add?
No, there are some questions that we had. I think we covered most of for what the time allowed, we covered most of what many TCPAs, how the agencies protect themselves and the risks. I'm glad, I'm going to end this poll, but I'm glad that a lot of the people that answered found this webinar helpful. So out of 50% at least that voted, 66% of the people that voted found this helpful. So we're going to pass along the information to the users that are interested on further help to Philip, and anyone that's interested on offsetting this registration, we can then discuss next week how we can help them have their clients registered to the Twilio A2P registration. Basically, what I created was the same screens that you would do that, but you just passing on that information, so you don't have to build a form, have them filled out, and then you have your VA or your team submitting this themselves. It just does minimizing these back and forth steps. That's what this is doing and helping.
Yeah, Helder and I, we went at length in communicating with Twilio what can be possible in structure of the organization and the registration. So that's going to be implemented into the form. And additionally, I think I'm really appreciative of Phil being on board on this. He's very busy, obviously.
Philip, can you answer Tom presented this question I think everyone wants to know at the end is, do you have a rule of thumb for a small marketing agency cost for the audit?
It depends. Look, I'm not in the business of overcharging. If it's a small agency, we'll work with you to be reasonable. Again, it just depends. Typically, the number that I have in my mind is between $2,500 and $5,000 for a small agency. And we bill hourly. Whatever we don't bill is returned to the client at the end of it. But it is very case specific. I don't think it's a ton of money if you're dealing with thousands of leads, if I'm being honest.
Yeah.
Thank
So,
you.
Phil, I may be wrong in saying this, but a lot of this, the technical aspect within HighLevel, we share the same tools. Basically, it's the same thing, how the form are filled out. A little bit of the technical may be different. I may be able to gather people that are really interested in doing the audit, and we can unify some of that. And hopefully we can, depend on what ethics say, but can we do that if we want to do that and present like this is this the right way to do it? If we can present it and pool, because a lot of us are small, and pool resources to make sure we do things right.
Yeah, again, I have to run that by my ethics counsel, and just so everybody's aware, ethics counsel is, you always have to run everything by ethics counsel, and you're kind of this newer space of audits on behalf of collectives. But if a group wanted to pool resources and essentially say, hey, we're 3 or 4 different companies and we want to pool resources and we want to pay you guys to tell us if we're doing it okay or not, I think that makes sense. I think we can figure something out there.
Okay, thank you, Phil. I appreciate that. I think a lot of people will be relieved that can be done. And obviously, guys, if you like, I just want to say if we do that and you have 100 clients and another dude that has 10 clients, it's going to be weighted. If we're going to do that, it's going to be weighted based on what you're asking for the legal counsel for Phil to do. I've got initial permission. I don't know how, again, we don't know how that will look like, and Phil needs to take it to ethics. And more than anything, we want to make sure we do things right. I think what we have been led to believe is just load the list and fire off, and that's okay. And to me, I thought about that in the very beginning and had concern. The more I read now, that's not okay. Now, you don't know where the leak. I personally stopped. I have this fancy workflow that catches errors, and I spent tremendous time in catching errors, but it did not avoid the primary question is what Phil said. Where did the phone number come from? Was there consent on it? I don't know. And they gave me a list. Take it. So I want to end this by saying thank you very much for showing up. This is my first doing live webinar, and we're new at this, and I want to share this with everybody so we can be doing things right. Okay, and I want to thank you, Phil, especially to being on, and Helder. We're working together with this. Phil, Helder, do you have any last comments? And Phil, do you have any last comment? Helder, you go first.
No, I'll just give the floor to Phil to wrap up. And I appreciate you actually coming in and being flexible with your practice and on your experience, expertise.
Hey, Joe, Helder, thank you for having me on here. Everybody, thank you for joining the call. It was a pleasure speaking with you. And I hope to be in contact in the future. But if not, I wish everyone the best with their business and everything else.
Thank you very much, Phil. I think we're at 3